Lucy Connolly says she was a political prisoner of Sir Keir Starmer, the United Kingdom's Prime Minister. That sounds dramatic, it sounds shocking. But let's pause, let's examine the facts, let's separate the law from fiction. And let's think why this case is being highlighted by opposition groups and some parts of the media, including social media. Here's what happened. On the 29th of July 2024, just hours after the tragic and brutal murders in Southport and subsequent disinformation, Lucy Connolly posted on X. She wrote, and I'm quoting, which is taken directly from the court records, "Mass deportation now, set fire to all the effing hotels full of the bees, for all I care. While you're at it, take the treacherous government and the politicians with them. I feel physically sick knowing that what these families will now have to endure. If that makes me racist, so be it." That single post was viewed more than 310,000 times before it was deleted. And this wasn't an isolated incident. During the police investigation, the police traced other tweets too by Lucy Connolly, which also contained remarks, and they can be found here and here. That is the basic factual background, but please do your own research. Now, the offence Lucy Connolly was charged with wasn't invented just for Lucy Connolly. It wasn't even created this century. She was charged with the Public Order Act 1986, specifically Section 19, which is in short, publishing or distributing written material with the intent to stir up racial hatred. This criminal offence has been on the statute books for almost 40 years. And it exists for a reason, to stop people actively stirring up and inciting racial hatred, which leads to violence. In criminal law, words matter. You can be convicted for the criminal offence of simple assault just based on words alone. And when words, even on social media, even those that have been deleted, tip into inciting racial hatred, the law draws a hard line. Now let's talk about the criminal justice process. Lucy Connolly wasn't dragged through a political show trial. She was arrested in early August. She was later charged. Her first appearance was on the 10th of August. She had full legal advice. She had representation at court by a legal team. She was given choices to plead guilty or not guilty to the offence of Section 19. And Lucy Connolly alone made the decision to plead guilty on the 2nd of September 2024. That matters. Nobody silenced her. Nobody twisted her arm. She had time to think about her plea. She admitted the offence in open court by her own free will and her choice. And the sentence for Lucy Connolly, well, the maximum sentence for this offence is 7 years in prison. Both prosecution and Lucy Connolly's own defence team agreed on the category status of this offence, that it was A1, high culpability, and her own barrister said she intended to incite violence. The starting point, according to the sentencing guidelines for this offence, is 3 years. The defence put forward her mitigation concerning the offence, one tweet which was deleted in hours, her personal circumstances, loss of a child, and the mistake she made in making the tweet. But when it came to the sentence, the serious unrest at the time, and the tweet was clearly an aggravating factor that increased the sentence beyond the starting point. The sentence was delivered by His Honour Judge Melbourne Inman KC in October 2024, not by Sir Keir Starmer, not by the Labour government. In Britain, in England, judges sentence, not politicians, not yet anyway. She received a sentence of 31 months imprisonment. Lucy Connolly appealed the sentence, but not her conviction. She argued the sentence was manifestly excessive. In May 2025, the appeal court ruled it was not manifestly excessive, rejecting her version of events. And please read the appeal, why the court rejected her version. And so the imprisonment of 31 months remained the same. No loss of time order was made, meaning any time she served would still count towards her sentence. That's the rule of law. It was followed here exactly as designed in Lucy Connolly's case. Now, of course, you and I can criticise the law, and I've done many posts criticising the law. Some argue the offence is too broad. Some say the sentence was too harsh. These are legitimate debates to have. But the issue here is about the statute and the sentencing guidelines and the aggravating features, not about the Prime Minister personally jailing a political opponent. To say Sir Keir Starmer locked up Lucy Connolly is pure fantasy. To say that she was a political prisoner, it's just not how the system works. And what about the constant comparisons we hear? But what about the Labour councillor, Ricky Jones, who was charged but walked free? I hear some and read. As reported, a suspended Labour councillor who called at an anti-racism rally for far-right activists' throats to be cut has been found not guilty of encouraging violent disorder. Well, here are those facts. That councillor pleaded not guilty and was acquitted by a jury of 12 complete British strangers. Acquitted not by Sir Keir Starmer, acquitted not by the government, but acquitted by 12 people in a jury after hearing the prosecution and defence case. Different facts, different case, different choices made by the defendants, different outcomes. Lucy Connolly could have pleaded not guilty. She could have elected a jury trial, but she didn't. And if she's now blaming her lawyers for poor legal advice, then she should consider making a complaint. But warning alert, there is a risk that she would have to waive privilege, and that would disclose conversations between her and her legal team. Now, to equate these two cases is misleading and frankly ridiculous and two-tier nonsense. You might also compare other cases and other sentences with sentences Lucy Connolly received, but again, focus on the maximum sentence for each offence, the sentencing guidelines, and the sentencing judge, not the politicians. So why the uproar now? Why the headlines? Because Lucy Connolly has been released from prison, because she's claiming to be a political prisoner of Sir Keir Starmer. It creates drama and a story the media can package and undermines the government and promotes an agenda which feeds into populist parties' narratives. And across the Atlantic in the United States, certain outlets are already courting her. Again, why? Because they want a British voice to bolster their endless culture wars about free speech. She's being used, according to certain critics, weaponized as a symbol. This isn't about justice being overturned. It's about narratives. It's about media cycles. It's about clicks. It's about populist parties. It's about certain media outlets. It's about culture wars. And the odd thing is, if you want to criticise and undermine the Labour government and the Prime Minister, you could easily point to other topics, more credible claims and accusations, such as complicity in genocide, rolling back on promises made during the general election in 2024, curtailing free speech by banning groups. So let's be absolutely clear. Lucy Connolly is not a political prisoner of Sir Keir Starmer. She was prosecuted under a law passed in the 1980s. She made comments on X in 2024, not just one, but others too. She took legal advice and chose to plead guilty to Section 19 of the Public Order Act, stirring racial hatred. She was sentenced by judges, not by politicians, and the rule of law, that great British value, was upheld and followed. You don't have to like the law. You don't have to like the sentence. But blaming the Prime Minister is fantasy. And for the record, I'm not a card-carrying member of the Labour Party. I'm a card-carrying member of being fair and just. In my opinion, Lucy Connolly's case is being spun for headlines and weaponised for political gain. And parties and groups are winning votes on the back of it. But what do you think? As always, feel free to comment, subscribe, follow, like, and share.